Hi, folks. This is Attorney Kip Malek, and now I'm going to be talking about a full commission decision. So, involving a claim allowance. So, this is kind of a fun one. Well, I mean, it's not fun for the claimant, but it's kind of an interesting fact pattern. So, it looks like August 24th, 2022, this injured worker had tripped and fell after stunned by a bee, and he was trying to run away from that bee. He was trying to evade it, as the commission writes it. And then so he looks like he suffered a left distal radius fracture. So it's not necessarily a fun injury. And so the SHO, this individual filed a claim with the Industrial Commission or the BWC, and the Industrial Commission, the staff hearing officer, the SHO, allowed the claim, and then the employer filed a request for a reconsideration, and then it was granted. And the full commission, what they looked at is what the individual's job duties. So this person was working on a small farm which housed 7 beehives. But at the time of the injury, this person was on a paid break, and I guess he was giving his father a tour of the improvements to the farm, and the father was visiting the farm on a purely personal visit. So the manager had testified that, one, the farm wasn't open to the public, and the claimant's job duties did not include giving tours. So the full commission, they said, hey, this injury did not occur within the scope of employment, and the claimant was instead pursuing a personal activity, i.e., giving tours to his father had nothing to do with the job, and therefore they disallowed the claim, which is kind of buzzkill for that kid or the individual. But it's weird. Every one of these claims and cases are, a lot of these things are highly fact intensive, and it just depends on how, the hearing officer, which hearing officer's hearing it, and then I guess who the commissioners are at the time. Because, you might look at this fact pattern, and I guess he is doing a purely personal activity, but it's kind of interesting because when you look at some of these fact patterns from these cases, there'll be people at the job, like they'll be on their lunch break, and they'll get injured on their lunch break, and then their claim will be allowed. And you would think, okay, lunch has nothing to do with the work activities, but the Industrial Commission or the court will evaluate that same kind of, not the same, but kind of a similar kind of thing, and they'll say, yeah, that did happen, at work or within the scope of employment. But usually, in order to be a compensable claim, the claimant's injury must be both in the course of employment, and this means something within the context of workers' comp claims. And so in the course of employment, basically what the case to say, it considers the time, place, and circumstances of where this injury occurred, and limits injuries while employed in a duty required by the employer. So if you look at this, this was not a duty required by the employer, and the employee engages in an activity that is consistent with the contract for hire or logically related to the employer's business. So again, giving a tour to his dad, not logically related to the employer's business. So therefore, not a workers' comp claim. But again, you can look at some of these other facts, and I might talk about some other cases that I've encountered where it's like, somebody, again, they're at lunch at work, and they get injured somehow, and it's a compensable claim, and you would say eating lunch is kind of a personal activity. So it needs to be in the course of employment, and then it needs to be arising out of employment, and then they say that's a causal connection between the injury and employment, and then the proximity of the injury to the workplace, the control that the employer has over the workplace or where the injury occurred, and then the benefit to the employer of the employee being at that place where they got injured. Usually that arising out of employment in the course of employment, usually you kind of analyze that in the context of going and coming cases. So this is a case involving some kid falling after being chased by a bee whilst giving his father a tour of the farm that he's working at. Not a compensable claim. It's kind of interesting. Nevertheless, this kind of goes with all these videos. Is workers' comps is in Ohio is so complicated and torturous that it behooves you to reach out to a workers' comp attorney, whether it's our law firm, Malek and Malek, or other workers' comp law firms in the state of Ohio. By all means, please call one or two or as many workers' comp law firms as you can and find somebody you like to work with and work with that person. All right. Hopefully you found something of value in this video. Thanks for watching. This has been Kip from Malek and Malek. Bye.